Good morning, everybody. Let me call this meeting to order. My name is Margaret Hinkle. I chair the Post Commission. We welcome members of the public who are in attendance today. Let me begin by taking a roll call of the commissioners who are currently present. Commissioner Bluestone,
I'm present.
Commissioner Crispin,
Present.
Commissioner Hall,
Present.
Commissioner Kazarosian,
Present.
Commissioner Luma,
Present.
and we currently do not have the other three commissioners present. With that, let me turn then next at this point to the executive director report. Enrique, please.
Thank you, Madam Chair, and good morning, commissioners. I'll share my screen momentarily and provide you with my report of the last month and upcoming milestones. Can everybody see my screen? Thank you. As part of my report, like I usually do, I'll give you an overview of the activities of last month and some of the recent and upcoming milestones. As a reminder to those in attendance, the Commission does not take public comment, but we very much appreciate and would like whenever members of the public want to provide written comments, to submit those using any of the resources on the screen, our general mailbox, our main number, and all of that can be done and found at mapostcommission.gov. So this morning I will give you a brief update on the certification numbers. I've been doing that in the past few months, given the most recent milestone of June 30th. And this will probably be the taper off in terms of going forward, because the team has mostly completed the big effort of all of these individuals that were up for recertification. I will move on to provide some metrics on the ongoing project that is our Disciplinary Records project, and then give you what is now a bit of a quarterly update on the complaints and incident reports that we are tracking as they come in. So last month, I provided a version of this chart as part of my report. I am including it here, given that some of the numbers have changed slightly, as I mentioned, as the certification team continues making progress towards that recertification effort. You can see that the majority of the applications have been successfully processed. The majority of those that have been processed do fall in the category of certified. And there's only a few that fall in the category of restricted or expired, or that they require further review. That number of further review applications has decreased almost by half. Last month, we had 116 applications that merited some further review. We are now at 68 and expect that some of that will be resolved in the coming weeks. So as of earlier this month, all agencies had submitted information that was required, and most of those applications, as you saw from the previous slide, have also been processed. Also, most notices have been sent out to agencies and individuals. They're also always available in our portal for individuals and agencies to go back and download or print any of those notices. Notices also include all the SRO certification notices, and also for reference, if an officer is suspended, they will not get, they do not receive any kind of notification, even if their prior certification was set to expire. Those officers who are suspended will continue in that category until further development on their case, specifically even when the suspension is lifted by the Commission. I want to emphasize that these numbers are often changing, given the fact that we have a large population of officers. And as a reminder, the certification timeframe is now more than 3 years plus the number of months that it takes to get somebody to the month of their birth date. Therefore, we will have some certifications now expiring in 2029, specifically the first half of 2029 for those officers that are born between January and June. Their certifications expire in the appropriate month, either between January and June. So as I updated the commission in last month's meeting, we also report the expired certifications of those individuals who are unassociated from an agency. And of course, their certification is expired given this milestone. This is an updated list of those individuals who fall in that category. Similarly, we have 647 individuals whose certification has been restricted and is also reported accordingly. Most of the officers in this category simply retired or resigned, and it is only a few officers who we track closely that, depending on the circumstances of their departure from the prior agency, like the ones at the bottom of this screen, if they were retired or resigned in lieu of discipline or were terminated, we, of course, track them closely. So I want to move on to the update on the Disciplinary Records project. This chart shows the progress over the last year by the different dates here designated here regarding the number of complaints that we publish in our public disciplinary records database. There are 3 different categories given the of how we think about or group these records. The first category is what we call the historical disciplinary records, and that includes all those records that were submitted to us as per the statute between January and March of 2022. These were the history of officers who were active at the time and whatever had happened prior to that date. The second category is what we became to label the catch-up project. These are complaints that were being submitted during that time, mostly between 2022 and early 2023, but prior to the rollout of the portal, which is the third category. So the portal opened in March 2023, and as you can see from this slide, there has been a steady increase in the records published in all 3 categories. This, of course, reflects the efforts of the team working on this project because it's a lot of analysis that they have to do. There's been a lot of conversations with agencies relative to quality assurance of these records and accuracy, and that has been a steady progress. As you can also remember, each of these numbers are unique complaints. Each of these complaints may include more than one allegation, which is also something we track closely. But of course, there could be at times only one allegation. It's at least one allegation or more. And there may be also a discipline associated with each of these complaints, including a pending discipline, if that is the case, because we publish records that have been closed, even if the discipline has not been imparted. So you can also see in this chart that the rate of increase is slowing down for both the historical disciplinary records and the catch-up project. That is, of course, due to the fact that agencies and the team at Post doing this review are steadily concluding our review of those complaints. They have been closed out, etc., as we receive that information. However, the rate of increase in the third category, in other words, the portal category, is rapidly increasing. And that is, of course, given that, or due to the fact that we are getting new records almost exclusively from the portal, where information has been flowing since we opened it. That is not exclusively from the portal. There is still some catch-up. We learn about things that may have not been submitted to us in a variety of ways, and that means we will continue to increase and reflect it in the other categories. But we expect that in a short period of time, the portal will take over as the main source of information for us to track and publish. I will move on to our report on the recent numbers regarding compliance. As I have reported to you in November of last year and February and May of this year, I report on a quarterly basis the different metrics we track regarding different complaints and incident reports that get submitted to us. Comparing prior reports provides, in my opinion, a good visualization of the trends and analytics, and it should also incentivize agencies to continue their compliance. So this first chart depicts the open complaints and the incident reports that are in the portal and have exceeded the 90-day closing requirements. The figures in this chart do not include cases or reports where the agency has requested and obtained an extension from post. This is simply the regulation requirement, the regulation that is in our, the requirement that is in our regulations of completing a report that has been submitted to post within 90 days of submission. I will report that those figures on the subsequent slides, those that have been granted an extension, I will report that in the next slide. But although we typically grant requests for extensions, we do question extensions that significantly extend beyond 90 days and do not involve a criminal proceeding, so that we can track those categories closely. So as you can see in this chart, although there does not appear to be a significant change in the number of agencies that need to report the completion of cases or closeout complaints, that number has gone from 14 to 11 to 12, back to 11 in terms of throughout last year by quarter. There is, unfortunately, and the number of pending incidents is higher compared to November of last year. That number has gone from 18 to 24, up to 28, and now at 33. What I find interesting is that the agencies that appear with multiple reports that are overdue seem to be shifting from quarter to quarter, but Boston does appear to have moved to the top of the list, which is a trend that I will also highlight in the following slides. So this next slide shows the number of cases where the agency has closed the internal affairs investigation, but the discipline is still pending. It may be that the agency has imparted discipline, but has not reported it to post, or it may be that the information that they have not imparted discipline, which is what I suspect to be the most likely scenario. There appears to have been a dip during the last 2 quarters, February and May, from 56 cases down to 45 and 46, but we're now back to 57 cases, which is what was around the benchmark a year ago. It may be fair to say, just from looking at these numbers, that the variation in this slide is mostly due to Boston, as most other agencies are hovering below 6 cases or below, and the variability of 10 cases can be explained by Boston, as you can see from this slide. Now, this slide shows the average number of days that the discipline is pending, and this trend is frankly disappointing. You can see that the average number of days where the discipline is pending has gone up steadily for everyone. This is especially true for Boston, but Boston itself does not explain the also significant higher average in days that all other agencies have when it comes to imparting discipline. My intention is to continue reporting these trends and, of course, plan to dedicate additional resources from the team to individually inquire and analyze some of these cases and understand what is taking what appears to be longer time to impart discipline. Now, I am reporting the numbers in this chart for the first time. This chart includes all cases broken down by agency. For those instances where they have been granted an extension to complete the internal affairs investigation, I'm only listing those agencies with 2 or more complaints in this category. In other words, there are 13 more agencies with an open IA, but that's only one open IA. As I mentioned before, the regulation requires that they be completed within 90 days, but it could be extended for good cause. The Boston Police Department appears at the top of the list, with most cases pending the completion of an IA, which is more than twice those of the state police. So this final chart will represent the total from the 3 categories that I reported. From left to right, those are the numbers of complaints submitted to post where the IA result was due, but there has not been an extension, and they have passed the 90 days requirement. The second column is those where there has been an extension requested and approved, but there's still not a completed IA or internal affairs report. And the third category is those closed out cases where the discipline is still pending. As we move across the chart, we can see that Boston is the agency with the most cases, and that is most cases, especially compared to the state police. I find it striking that Boston is both the largest backlog, almost 3 times as much as the state police, which is an agency that is a little bit larger than Boston. So we continue to have conversations with the Boston PD unit that reviews these investigations to figure out ways in which we can collaborate to make these numbers go down as we continue to track them. So let me pause there. This is my last slide. Let me pause there, commissioners, and see if there are any questions or comments. Seeing none, I think, Chair, that concludes my report.
Thank you very much, Enrique, and thanks to the members of the staff who have worked with you on the material that you presented to us. Commissioners, I know greatly appreciate their efforts as well as yours and the clarity that you provided in giving us this information. Moving on, and if I can note that Commissioner Talley has now joined us, it will be present for the remainder of this session. Moving on, please, to the legal update. Randy, please.
Thank you very much, Madam Chair. First, I'm pleased to report that just this week, Post-Commission Counsel Everett Fowle was selected to be part of the Boston Bar Association's Public Interest Leadership Program. As the Bar Association explains, this is a program for a select group of talented and highly motivated lawyers who have demonstrated leadership in their practice and community and represent rising stars who embody the professionalism, drive, commitment, passion, and diversity of the bar. Members of the program participate in a year of intensive leadership and professional development training in which they're connected with legislators, judges, nonprofit executives, and corporate leaders throughout Boston. Those who've worked with Everett will agree that the association made an excellent choice in selecting him, and we look forward to seeing him, the Post Commission, and the community benefit from his participation. Congratulations, Everett. Next, I will turn the floor over to Deputy General Counsel Pauline Nguyen, who will discuss an area of the law and a related initiative that is sure to be of interest to the Commission, to law enforcement and to members of the public. Attorney Nguyen?
Thank you, Randy. Okay, sharing my screen. Can you see my screen? Not yet.
Yes.
Great. Thank you. Good morning, commissioners. I'm going to provide you with an overview of the U visa and T visa programs and their relation to the work that we are doing. Before we begin, I'd like to acknowledge that one of our summer legal interns, Emmanuel Parker, was instrumental in bringing forth this issue. He also drafted language for the Post Commission's webpage that would give resources to victims who may be eligible for these types of visas. And I'll show you that at the end of the program. I'll start with U visas. The U visas are offered by the federal agency, the U.S. Citizenship and Immigration Services, USCIS. These visas provide immigration relief to victims of certain qualifying criminal activities. A federal regulation defines qualifying criminal activities to include crimes like rape, domestic violence, sexual assault, abduction, manslaughter, and others. I've included a longer list of the crimes here in case they are helpful to those who are watching as well. In order to receive a U visa, a victim, among other things, must suffer substantial physical or mental abuse and have been helpful, be helpful, or be likely to prove helpful, essentially cooperate with law enforcement in the investigation or prosecution of a crime. Some of the benefits of a U visa are that it provides the victim lawful status for up to 4 years, which may be extended, provides employment authorization, allows for the waiver of many inadmissibility factors, and may provide the same benefits to qualifying family members. An individual would need to apply for a U visa. Part of that application requires certification by a certifying agency, which includes local law enforcement, such as police departments. This form confirms that the applicant is a victim of a qualifying crime and has cooperated in the investigation or prosecution of that crime. Next, I will cover T visas. Federal immigration law also provides the T visa to victims of severe forms of human trafficking, including sex trafficking and labor trafficking. This visa provides the same or similar benefits as the U visa, as explained earlier, including that they also extend to certain qualifying family members. To be eligible for a T visa, an applicant, among other requirements, must have been a victim of a severe form of trafficking, had complied with any reasonable request for assistance in the investigation or prosecution of trafficking. There are exceptions that exist for minors and victims with trauma, and be at risk of suffering extreme hardship involving unusual and severe harm if removed from the U.S. To apply for a T visa, an applicant must provide evidence to establish that the applicant complied with any reasonable requests for assistance from law enforcement, or that the applicant qualifies for an exemption. The applicant may submit a form by a certifying agency or submit other evidence. While the form is not required, this form can significantly strengthen a T visa application by supporting the applicant's account of trafficking and cooperation with authorities. Moving on to state law. So in 2021, the Massachusetts enacted a statute, Mass General Laws, Chapter 258F, requiring state and local certifying agencies, such as police departments, to adopt policies for completing and signing certification forms for victims petitioning for a U visa or a T visa. This law also requires a certifying agency to respond to a petitioner within 90 days after receiving a request for certification by either 1, completing and signing the certification forms, 2, issuing a written denial of the request, or 3, issuing a written explanation of the delay, the process for the certifying entity will undertake to respond, and a projected time frame for such response. So in sum, the state law requires law enforcement agencies to have an internal policy on the UNT visa process. It requires that responses are provided within 90 days and requires a written explanation of any denial or delay. The statute was enacted to ensure statutory due process for immigrant victims applying for UNT visas, giving them statutory rights to challenge a denial of a certification. I think it also signals the state legislature's interest in providing protections for immigrant survivors of crime. So the role of law enforcement. In terms of the role of law enforcement, Massachusetts police departments play a vital role in both the UNT visa application processes, particularly through the completion of a law enforcement certification form. There are certain considerations for law enforcement agencies on this topic. The first is that certification is voluntary. However, it can be a powerful tool to encourage victim cooperation, increase trust in law enforcement, and improve successful prosecution of crimes. Law enforcement must develop policies for reviewing and completing certification requests to ensure consistency and accountability. They must also respond to certification requests in a timely manner. Law enforcement agencies must handle requests and victim information with sensitivity and confidentiality, recognizing the vulnerability of crime victims, particularly those with immigration concerns. The USCIS and its parent agency, the Department of Homeland Security, among others, have pointed out the benefits of certifying a victim, including that it is part of a victim-centered approach, creates trust within the community, and encourages others to report serious crimes. So UNT visas serve as an essential humanitarian tool to protect non-citizen victims of crime and trafficking, while simultaneously strengthening law enforcement efforts to investigate and prosecute serious criminal activity. Law enforcement certifications are often decisive in the success of these visa applications. As such, law enforcement agencies play a critical supportive role in ensuring access to immigration relief for victims who are instrumental in criminal investigations. As pointed out at the beginning of this presentation, with the help of Manny Parker, the Post Commission will be updating its Victim Resources webpage to include information on these visas for crime victims. I've put a link to the webpage here, and this is essentially what the page currently looks like. Something will be added, something like this will be added to the webpage notifying crime victims of the visas that are available to them. And with that, I will end my presentation and take any comments or questions.
I actually just have a comment, Pauline, around that. What are we seeing? I know we use U visas quite a bit with survivors of domestic violence. Under this current administration, I mean, there's some fear of immigrant survivors, particularly of domestic violence, coming forward out of fear of being deported. I don't know how much research you all have done, but I imagine the number of immigrant survivors of domestic violence that are applying for a U visa has gone down dramatically, or there's no follow through because we don't know. I know, of course, the administration didn't get rid of it, but definitely priorities have changed. Can you speak to that, or you know anything about that, or what you're seeing?
Yeah, there hasn't been, in terms of research on the role of immigrants seeking this type of visa and sort of its impact on the work that we're doing, that is something that certainly the Post Commission could be looking at and do in addition to the work that it's doing around domestic violence and sexual abuse.
Commissioner Talley, I think, has a question.
Yes, thanks. So I'm assuming that this information with the U visa and T visa is more known for those who deal with domestic violence and crimes associated things. Because this is my first hearing about the U visa and the T visa. Is that the assumption?
So in terms of the information that is provided to victims of domestic violence or crimes, I believe that social service programs do provide this information to victims. I don't know if another commissioner could speak more to this, but to the extent that this information may be new to us or new to police departments, including that new state law that was recently enacted, that information may be new, but I think that victims, or at least victims who seek services at service agencies, will be provided this information.
Okay, thank you.
Commissioner Crispin?
Yes, so just good morning. I think on our end, the victim witnesses advocates tend to be very tend to provide all this information to victims of crime. I know I filed a couple of them for people who are victims of civil rights offenses. I think the concern for a lot of people is whether or not they're actually going to get them, because the applications tend to exceed the numbers of visas that are given based on the information I have.
And it's the same here. It's the same at the district attorney's office too. Our staff here are aware of U and T visas and will support the application process when appropriate.
Thank you. Any additional comment or questions? If not, Pauline, thank you very much for the presentation. And let me move on now. Back to you, Randy.
Thank you very much, and thank you, Pauline, for that presentation and your work on this. I will now turn things over to Counsel Annie Lee, who will discuss the latest standards for your consideration regarding officer response procedures as part of the agency certification initiative.
Thank you, Randy, and good morning, Madam Chair and Commissioners. I believe I'm now sharing my screen. And so, as Randy said, today I will be presenting on officer response procedures. I will be presenting proposed revisions to the last draft. I am not seeking the Commission's preliminary approval of the standard today, and I'm looking for the Commission's further feedback and reactions. This standard was last before the Commission in April when it was presented for your initial feedback and reactions. You had a fulsome discussion, and following the Commission's meeting, Commission staff sought the feedback of the MPTC and its staff as directed by statute. The MPTC provided that feedback last month in July during its public meeting. The revisions that I will be presenting today reflect feedback and suggestions that have been provided by you during the April meeting, the MPC during its July meeting, as well as other members of the Commission's staff in the time between April and today. And so those revisions relate to the elements of officer response procedures that are highlighted in yellow, which are officer conduct, responding to vulnerable people, enforcement quotas, immigration matters, and body-worn cameras and vehicle recording systems. I'll note here that the revisions concerning officer conduct, responding to vulnerable people, and body-worn cams and vehicle recording systems are revisions to elements that were part of the draft standard that was presented to you in April. Enforcement quotas and immigration matters are proposed new elements of this standard, which I will discuss. But before turning to those, I wanted to bring to your attention two revisions to the definition section. And just quickly, I wanted to note that a copy of these revisions are in your packet starting at page 63. But the first revision to definitions is to the definition of critical incident. When officer response procedures was last before the Commission in April, there was a robust discussion about the definition of critical incident. You discussed whether critical referred to the nature of certain events or to the impact that events may have on an officer and their well-being. To that end, you suggested striking the last sentence of the original definition, which sort of enumerated some examples of critical incidents. And so in addition to striking that last sentence, I'm proposing today that the commission revise the last few words of the first sentence. So it reads, a sudden or progressive development or event that requires immediate law enforcement attention and decisive action to prevent or minimize any negative impact on the health, safety, or welfare of a law enforcement officer or another, to recognize that certain events may both be inherently critical in nature and have a profound impact on responding officers. The second revision is to the definition of developmentally and age-appropriate, trauma-informed, racially equitable, and culturally relevant tactics and techniques. This standard, as well as other standards, including use of force, criminal investigation procedures, and juvenile operations, makes reference to this phrase, which originates from the Commission's enabling statute and is also used in the Commission's 2021 guidance on developmentally appropriate de-escalation and disengagement tactics, techniques, and procedures, and other alternatives to the use of force for minor children. However, in seeking the feedback of MPTC asked us to clarify what tactics and techniques would satisfy this phrase. And so given that what will be developmentally and age-appropriate, trauma-informed, racially equitable, and culturally relevant is going to be highly dependent on the facts of an interaction, who's involved in the circumstances surrounding that interaction, the definition that is proposed before you today suggests that rather than listing out specific tactics and techniques that are developmentally and age-appropriate, trauma-informed, racially equitable, and culturally relevant, when officers utilize their critical thinking skills to examine how they may adjust their tactics and techniques to better meet the needs of the particular individual with whom they are interacting. And so when I say to better meet the needs, those are needs that may be informed by an individual's contextual factors, including mental or physical condition, age or developmental maturity, language or cultural differences, the legacy of policing on vulnerable populations, and the agency's history with the public. So essentially recognizing that folks come from all sort of different walks of life and may have different needs and may present in different ways, and there are ways that officers can try to utilize critical thinking to be more responsive to a particular individual. Next, I'll be discussing 3 revisions that pertain to previously presented provisions in officer response procedures. The first concerns officer conduct. So as originally presented in April, this section called on officers to, among other things, proactively explain to a member of the public how they may follow up on, raise concerns about, or file a complaint about the agency, the officer, or the response. The intent of making the requirement proactive was to lower barriers and reduce intimidation that may otherwise prevent someone from seeking more information about or redress from an interaction with an officer, with the larger goal of increasing transparency and improving public confidence and trust in officers and policing. The MPTC and its staff, however, raised concerns about the practicality of a proactive requirement and the potential negative impact that a proactive requirement could have on officer morale. And so to try to balance the original intent of this requirement with MPTC's concerns, we're proposing revising this requirement in 2 ways. So the first revision is to have officers proactively provide their name, badge number, and contact information so folks know who they're interacting with. And then second, only when circumstances reasonably dictate, including upon request or an expression of dissatisfaction, will officers then be required to explain to an individual how to follow up on raised concerns or file a complaint about the agency, officer, or the response. The second revision concerns responding to vulnerable peoples and specifically the administration of pharmacological agents. And so the draft is presented to you in April, set forth requirements or directed agencies to set forth requirements concerning the administration of sedatives and pharmacological agents, including ketamine outside a hospital setting by officers. So in other words, the prior draft standard directed agencies to address whether officers would administer sedatives and pharmacological agents outside a hospital setting, and if so, the requirements that had to be satisfied prior to doing so. That directive was based on the White House's May 25, 2022 executive order on advancing effective, accountable policing and criminal justice practices to enhance public trust and public safety, as well as the circumstances that surrounded Elijah McClain's death in Colorado in 2019. And so when we sought the feedback of MPTC and its staff raised concerns that the original language could be read by agencies to imply that agencies should carry and officers should be permitted to administer sedatives and pharmacological agents outside of hospital settings, even those that are controlled substances under Massachusetts law, including ketamine. And so what we've done here is we've tried to revise the standard to clarify that agencies should, one, set forth requirements concerning only the administration of permissible pharmacological agents, which we understand is primarily naloxone. And then second, prohibit the administration of impermissible pharmacological agents as defined by Massachusetts law, which includes ketamine. And so the third and final revision to prior provisions of officer response procedures concerns the deactivation of body-worn cameras and vehicle recording systems. The prior draft standard directed agencies with body-worn cameras and in-car audio or video recording systems to set forth requirements concerning the deactivation of those cameras and systems, but in any case prohibited the solely and purely discretionary decision to deactivate the camera or system by the same officer wearing or operating the camera or system. So essentially the prohibition was really to try to capture those outlier events, but those still troubling ones where an officer who knows they're about to engages in misconduct turns off their body cam or some other recording system in order to sort of get away with this misconduct. And so the MPTC was in agreement with that, but they sought clarification as to when a deactivation decision would not be solely and purely discretionary, such as when an alleged victim asserts that they don't want to be recorded. And so to try to address those concerns, the revisions here try to clarify that deactivation decisions are not solely and purely discretionary when, one, entering a location where the recorded individual has a reasonable expectation of privacy. So, for example, when an officer is entering someone's home. Two, when interacting with an alleged victim of a crime. So to this MPTC example, if an officer is responding to, say, a domestic violence call, someone can say, I don't want to be recorded. That would not be purely discretionary. And third, interacting with an individual who seeks to anonymously make a report, whether that's criminal activity or the like, or to assist in an ongoing investigation. And with all of these, in addition to sort of these three fact circumstances, we're sort of saying that the deactivation here is not solely and purely discretionary when the recorded individual themselves say they do not consent to being recorded. So an officer can't assert that right for someone. The individual has to assert that right for themselves. And so the final two revisions I want to review with you today are new elements in officer response procedures that I mentioned earlier. Those elements came about through discussions and suggestions from commission staff, including Pauline Nguyen, Emmanuel Parker, and Gerald Cahill. The first new revision concerns enforcement quotas. Commission staff raised concerns about the use of enforcement quotas by agencies, whether those are traffic enforcement quotas that the agency has or quotas that are imposed on an agency by virtue of their cooperation with another law enforcement agency that has quotas. One example of this, it's been widely reported that ICE has imposed a daily quota for immigration arrests, and those local police departments that are assisting them in those efforts through that cooperation are then subject to ICE's enforcement quotas. And so here we're suggesting that to increase transparency and correct any misconceptions regarding an agency's use or non-use of enforcement quotas, the revised standard, the the standard should be revised to suggest that agencies should memorialize in writing their policy concerning the use of or prohibition against enforcement quotas. So not taking a stance on whether or not enforcement quotas are permitted or banned, but more so to sort of say that agencies should be explicit about whether or not they use enforcement quotas. The second and final addition to this standard concerns immigration matters, which addresses two topics, immigration enforcement and U&T visas, as we just heard from Pauline. And so first on immigration enforcement, as we're all aware, in recent months, communities in the Commonwealth have experienced an increase in immigration enforcement activities. This increase has led to many questions about state and local law enforcement's relationship to federal immigration authorities and state and local law enforcement's role in those federal immigration enforcement actions. Because cooperation by state and local law enforcement with federal immigration enforcement is voluntary, and municipalities and agencies throughout the Commonwealth have passed and adopted various bylaws, department rules, regulations, and policies concerning this cooperation, the draft here suggests that, just similar to enforcement quotas, as a matter of transparency, all agencies in the Commonwealth should address their particular agency's role in cooperating or not cooperating with immigration enforcement activities. So essentially hoping to provide folks in the community with a better sense of what their local police department is doing relative or is not doing relative to immigration enforcement. The second piece on immigration matters is on U&T visas. As we just heard from Pauline, USCIS offers visas for victims of certain alleged crimes and their qualifying family members. And the legislature in 2021 enacted a law which requires agencies to play a role in certifying forms necessary for these victims to apply for U&T visas. And so the revision here suggests that agencies should, in accordance with General Laws Chapter 258F, one, develop a policy for completing and signing the necessary non-immigrant status certification forms, and two, respond to requests to complete and sign non-immigrant status certification forms. We understand that anecdotally, this has not necessarily been the case at every police department, despite the existence of General Laws Chapter 258F. So the hope here is that by putting it into an agency certification standard, we're highlighting what may a law that may be unknown to some agencies, but also sort of if there are any departments that or agencies that are not complying with this law, there's potential that the commission could take enforcement action based on that non-compliance. And so with that, I will stop sharing my screen. I'd be happy to answer any questions or to take any reactions from the commissioners.
I don't think I see any indication of questions. Thank you very much, Annie, for that presentation. And thanks also to the MPTC that has worked with you in some of the clarifications and additions that you described today. We're grateful for the level of cooperation that we have with the MPTC. I think with that, Randy, anything further with regard to legal matters?
Nothing further. Thank you.
Thank you. Moving on then to the Division of Standards update. Matt, please.
Good morning, Sharon. Good morning, Commissioners. Thank you. I'll share my screen in a minute. But before I do, I just will introduce the topic that I wanted to talk with you today about. So I'm going to share with you a proposal that members of the division staff have been working on to update or to propose some updates to procedures regarding the reporting of complaints by law enforcement agencies and how the Division of Standards handles those complaints. We're not asking for a vote on anything today, but we're just looking to provide you with a high-level overview of the changes that we think might be necessary and hopefully collect some initial feedback that will guide further work on this topic. So the issue concerns how the Commission defines so-called minor complaints. And so let me, probably a good time that I should share my screen at this point. So give me a minute while I do that. All right, is that coming through?
Yes.
Okay, excellent. All right, so this is an important area because our statute, which you can see on the screen there, sorry, I myself can't see it. There we go. It's an important area because the statute allows the commission to create basically a line below which low-level matters don't need to be reported to the commission, or perhaps could be reported, but dealt with in a more expeditious way. So what I'm going to do is I'll start by talking about what the statute says right now, and then I'll talk about the current state of the regulations that we implemented 3 years ago that implement this provision of statute, and then briefly cover what the updates we are proposing would be, again, at a high level. So the goals here are not to increase or reduce the levels or types of things that agencies submit. Rather, as I'm going to explain, the two goals here are to find ways to clear up what the lines are, and also to find improvements in our processes that are going to allow the division to handle some lower level complaints that are reportable, but in a more streamlined way. So on the screen right now is the relevant part of Section 8 of our statute. And it says basically that an agency shall transmit any complaint received by the agency within 2 business days. But then there's a proviso, and there's 2 important elements. That the proviso says that the commission can establish a minimum threshold and a streamlined process for the reporting or handling of minor complaints. And it does say that minor complaints cannot involve the use of force or allegations of biased behavior. So aside from those 2 carve-outs, though, it makes clear that a minor complaint can't include the use of force or allegations of biased behavior. Other than that, it's pretty wide open for the commission to define in a way that it sees fit. So in addition to that, there's another statute that also in Chapter 6E that's relevant to the commission's obligation to collect internal affairs data from agencies. And that's in Section 4H. It's a certification statute, but it does require the commission to collect information about written reprimands, about suspensions, about internal affairs complaints, and about the outcomes of those investigations. And I think for efficiency purposes, we've read those statutes together and thought about them basically as collectively addressing the types of things that agencies have to submit to us when it comes to internal affairs matters. So we have spent the last 3 years at the division working with the current line and how the commission initially chose to define minor matters. And on this slide right here, I've tried to visualize what the current state is as to what our regulations currently provide. As you can see, there's everything that's not minor. So there's the default that any complaint is submitted to post unless it's a minor complaint. And the way we currently define them is to say that it's a category that includes certain behaviors. And you can see there discourtesy or work rule violations. Our experience in working with this definition is that it's a little open-ended. And I think part of the reason for that is that it says that it's a category that includes certain behaviors. That obviously implies that there could be other forms of behaviors that are not listed in the regulation that might also be covered. And so I think one consequence of that is that it's led to some ambiguity or questions by agencies and even internally as to what individual fact patterns constitute minor, what are not. And of course, as I've explained, the difference matters because minor complaints can be resolved solely within the agency. Other complaints that are more serious need to get reported to post. And so you'll have these sort of fact-based inquiries that are sort of difficult to square, difficult to keep to consistently apply. And the strange thing for us is that you have a definition that I think could be viewed as broad, when in fact I think the intent is that it should be narrow. That is, that the commission should be receiving the vast majority of complaints from agencies, and the category of what's minor, rather than being broad, should actually be read narrowly. And that's sort of how we've, in practice, been doing it. But there's been differences in terms of working with that in practice. Secondly, the statute that I showed you talked about a streamlined process, not just the reporting threshold, but also a streamlined process. The regulations don't really speak to that today. There is the agencies can resolve minor things at the local level without any post involvement, but there's really not a middle ground. There's things that sort of fall in between that we think we should be seeing that should be submitted to post. We at the division basically have to monitor with the same level of attention and oversight that we give, the most serious complaints. And so we're looking for a way to continue to collect all of the information that we need. Again, not really trying to change what's being reported to post, but we are trying to find ways to make that line a little clearer, and also find efficiencies where we can that will let us identify some lower level matters that are reportable, but maybe handle and process them in a more efficient way. So that brings me to the real point of the presentation, which is the two main areas that we're recommending to be addressed. So we think that we should revise the definition of minor matter or minor complaint, and we should do that in a way that more clearly reflects how the commission interprets the line between what is serious and what is minor. And we think that if we can do this successfully, we'd probably improve agency compliance with post-reporting obligations. Second, we think that the statute authorizes the commission to implement a streamlined process for some minor complaints, but we haven't yet implemented that, and we think that it would be a good idea to do so. There's a large category of complaints that probably would not justify, opening a preliminary inquiry or pursuing discipline, but we still want reported to the commission. We still want to be able to publish those sustained allegations in the disciplinary records database, but they are less serious than the most serious complaints that we get. And we think that if there's ways to reduce the touch points or gain some efficiencies in processing them, that we could take advantage of those as well. So with that being said, this next slide is at a very high level one way that we could accomplish that. So there's still a single line between minor matters and serious violations, but we're proposing to define them a little more fully. The first category is what we call serious violations of law enforcement standards, and those would be handled as they are today. There'd be no change there. But rather than being open-ended, we would propose to define them specifically. We would look through every provision of Chapter 6E and other applicable statutes. It would identify all of the forms of misconduct that would support the commission pursuing an investigation, a suspension, discipline of some kind. Anything that the legislature specifically tasked the commission to look at, we would designate as serious. We didn't start from a blank slate with this list. I don't think we need to do that because there's already been a lot of work done in that space. A couple of years ago, the commission published a guidance document that interpreted the current version of our regulations. And that guidance document has a pretty long and comprehensive list of things that are presumptively not minor. That list, I think, is a great start. We can build on that, add to it, modify things in there. But basically, that already reflects a very solid look through of the commission statute and current authority, and identifying the things that the legislature put under the purview of the commission. These are the things that would probably lead us to open a preliminary inquiry or pursue discipline. And so I think just from a standpoint of focusing our attention and our oversight authority on the most serious things, we would do our best to come up with a comprehensive list of the things that the commission is most interested in. And it would be based on existing statutory authority. For everything else, we would designate as minor. That's supported by the statute. But we would divide minor complaints into two, subcategories. And the first would be reportable to post. We would still expect the agencies to submit those complaints to post. And this would cover basically a lot of the things that they already have to submit, things that are more generic or that don't easily fit into one category or the other. There's some categories of allegations that we get: conduct unbecoming or neglect of duty, or things like that may not, that sometimes fall on the line. those are the cases that we go back and forth with agencies about whether it's minor or not. So rather than try to distinguish individual fact patterns, we would simply treat them as unprofessional conduct, which is just generally it's minor but reportable. So we would collect those, and we would also include any complaint that involves an interaction with the public, except for basic discourtesy, would be included in the category of minor but reportable. And then lastly, any other non-serious complaint, so anything that isn't in the serious category, that results in a formal discipline against the officer. So if an agency, at the end of an investigation, if the agency suspends an officer or issues a formal reprimand or orders them to undergo formal retraining, or terminates them or enters into a last chance agreement or things like that, any sort of formal discipline against the officer, that agency would then have to report that complaint. And you'll notice that we're proposing that it would be reportable, but not until the completion of the agency's internal affairs investigation. There's a few reasons we do that. And one is that it would allow the division to implement that streamlined process that I talked about, but we wouldn't have to continue to have these multiple touch points with the agency during the progress of an internal affairs investigation that frankly is minor and isn't probably going to lead to a preliminary inquiry or discipline. But it also allows the agency to complete the investigation, and then based on what the discipline is against that officer, it'll be a much easier task for both the agencies and us to figure out what's supposed to be submitted to post. If an IA completes with a written reprimand, that is a reportable complaint and it needs to get submitted under this proposal. The last category would essentially look a lot like what the current definition of minor matters is, but it wouldn't be open-ended. We would tighten it up and put a line around it. We would say internal work rule violations, we would say discourtesy, and we would probably end it there, subject to, as we go forward, we may add or remove things from the list, but the point is we want to put a line around it so that it's easier for agencies to understand whether their particular complaint falls on one side or the other, and it would then make it easier for us to enforce or to oversee those rules, and eventually, as I'll talk about in a few more minutes, to roll out to be able to audit these records in, I think, a more consistent and efficient way. So that is the broad outlines, I would say, of the proposal. We think that we can simplify the reporting process by, again, making things a little clearer, and we can also gain some efficiencies for complaints that don't require or that probably wouldn't lead to further action by post anyway. We could still collect those records while making it a little more efficient. So the goals really to increase transparency and accountability in the following ways. So talking about clear and unambiguous regulatory guidance that's based on statutory authority. These are the new category of serious violations would be easy to understand. It would be clear what the commission's focus areas are. We think that will help the commission focus on the kinds of allegations that are most squarely within its statutory mandate. Of course, we would still continue to collect information on lesser violations, as I've already explained. I've talked about the gaining efficiencies within the Division of Standards. I can tell you that that would allow us to provide additional oversight in the areas where we feel it's most necessary, and reducing the multiple checkpoints throughout the processes of these lower level complaints. We would continue to allow agencies to internally resolve very low level things that only involve sort of internal department functioning and then don't involve interactions with the public. And then, as I indicated a minute ago, looking ahead, the commission's really focused on standing up an audit function. And the clearer that our rules are, the easier it will be to conduct an audit on agency compliance. Clarity equals compliance, and I think it's when you have an audit program, I think one of the ways that can be most successful is if an auditor can easily put things into a yes or no distinction. If it's easy to measure, then it'll be more successful and we'll have more buy-in, and the program would be more effective. So with that being said, the proposal for next steps, we'd like to continue to work internally on this and sort of flesh things out in more detail. Wanted to provide you with the high level feedback at this meeting just to get your initial reaction if you have any. And if the commissioners are amenable, we would basically take your feedback back and then continue to work on more policies. We'd come back to you in a few months with some more detail, and then that would lead to proposed revisions to 555 CMR 1.01, which is where the minor matter issue is addressed. And obviously, we would present that draft with the specific line edits to the commission for approval as per the normal process for updating regulations. So the last slide here really just is just a link to some authorities that I relied on. Welcome your questions or your feedback at this point. Thank you.
Commissioner Talley.
Thank you, Attorney Landry. This is timely because I had an officer ask me a question that if there's a group of officers within their department that has a complaint about their chief, is that something they can submit to post? And I told him I'd find out. So I'm not sure if there's another route they're supposed to take since it's the chief of the department, or they can lodge a complaint with post.
The answer to that question is yes. The statute authorizes any person, any source, to file complaints with the commission, and they'd be welcome to do so.
All right, thank you.
Commissioner Crispin.
So I think this is timely in terms of, I think when we talk about these minor complaints, it varies from agency to agency. And I think it's super hard to specifically articulate every single incident that would amount to a minor complaint. I think a periodic audit would probably do that. And I think the other issue for me is this title of conduct unbecoming, because there's such a wide range of behavior that falls under conduct unbecoming. And depending on the officer and on the agency, one agency could title it something else, whereas somebody else labels it as a minor complaint and labels as conduct unbecoming. I think to the extent that we can specifically articulate the behavior and or do a periodic audit of the agencies, it would go a long way.
Thank you. Commissioner Luma, please.
Yeah, I just wanted to say thank you for just taking the time to put this together and bringing this forward. As we consider kind of really bringing clarity in defining minor and what's not considered minor, I also recognize that agency culture varies and is different. So what may be minor for one agency may be not for the other agency. So as we're thinking about those, I think it's important to standardize and streamline it, given capacity, agency culture, and other things that may come into play in defining what is considered a minor infraction.
Thank you.
Thank you. Other questions or comments from the commissioners? Let me echo the responses that my fellow commissioners have made. We greatly appreciate the presentation, Matt, and we look forward to continuing to address the issues that you raise here. I think with that, I would entertain a motion now to approve the minutes of the last public meeting. Is there such a motion?
So moved.
So, okay, I second.
I'm sorry, who moved?
I did.
Thank you. All right. Commissioner Bluestone,
Yes.
Commissioner Crispin,
Yes.
Commissioner Hall,
Yes.
and Commissioner Talley.
Yes.
I also approve, and with that, the minutes of, excuse me, the last public meeting are unanimously approved. Turning to the agenda, there are no matters not anticipated by me at the time of posting. I would now entertain a motion to go into executive session in accordance with Chapter 38, Section 21A1, to discuss the discipline or dismissal of complaints or charges brought against a public officer, employee, or individual under the same statute, Section 21A5 to discuss the investigation of charges of criminal misconduct, or under Section 21A7 combined with Chapter 6E, Section 8C2, and to the extent that they may be applicable, General Laws, Chapter 6, Sections 168 and 178, to discuss matters relating to preliminary inquiries and initial staff review concerning whether to initiate such inquiries and regarding certain criminal offender record information, and under Chapter 30A, Section 21A7, combined with Sections 22F and G of the statute, to discuss and approve the minutes of a prior executive session. We would be addressing report of preliminary inquiry. We would be addressing the Division of Standards request to enter voluntary decertification, suspension, or disposition in 3 cases. We would be also addressing a request for approval to conduct preliminary inquiries in a case, and we would be addressing approval of the minutes of the last executive session. Is there a motion to go into executive session in accordance with what I've just described?
So moved.
Is there a second?
Second.
Thank you. Commissioner Bluestone,
Yes.
Commissioner Crispin,
Yes.
Commissioner Hall,
Yes.
Commissioner Krasarosian,
Yes.
Commissioner Luma,
Yes.
Commissioner Talley,
Yes.
and I'm also affirmative, so that's unanimously carried. Members of the public, we will not be returning to the public meeting after the executive session. And I think with that, this public meeting is concluded. Thanks to all of the members of the public who have been in attendance. Enrique, do you want to again remind them if they have any questions, how they should provide those questions or comments to the Post Commission?
Yes, thank you, Madam Chair. postc-comments@mass.gov is our general mailbox, and mapostcommission.gov, our website where there's additional information how to get in touch with us.
Thank you. Thanks very much to all of the presenters today, and thanks as well to all the members of the staff who have worked with you on the detailed and provocative materials that you have given to us. We are exceedingly grateful for that. We will take a 5-minute break before we go into executive session. And with that, this public meeting is concluded. Thank you.